committee meetings wrap up and they can, migrate up this way. But in an effort to get everybody on home tonight at some point, we want to go ahead and get started. So let's let's start with Senate Bill number 2211. This is Senator Hill, I think, has this bill, and I think the Attorney General's office is also here. They're supporting this bill, but Senator Hill, you're recognized.
Interpersonal violence. And so it does three things on the committee. And the only reason why there's a committee sub, because the last thing was left out of the body. It was in the title, but it was left out of the body. It just basically says our statute lacks three requirements that's found in the federal code: the right to be informed in writing of policies governing the collection and preservation of sexual assault evidence collection kits. So all that is a copy of the policy of whatever law enforcement agency they're dealing with. Then the right to be informed of the rights under this subsection, all that is copy and pasting the subsection of the bill and handing them to the victim. And then the third thing is the right to receive written notification of intended destruction or disposal of the sexual assault evidence kit no later than 60 days before the date of disposal. That would be the only independent thing that would be required, other than a copy and a paste, is for that agency to notify that victim in writing that they were going to destroy that evidence within 60 days. And that's what the bill does. And if the AG's office would like to add anything, I'd be happy to let them.
Thank you, Chairman Gain, and thank you, Senator Hill. Gregory Austin with the Attorney General's office. And just like Senator Hill just said, this bill places three requirements that we don't have in our Sexual Assault Bill of Rights that are in the Federal Sexual Assault Bill of Rights. This would make us at a minimum consistent with the Federal Sexual Assault Bill of Rights, so we can qualify for these STOP grant funds, which flow from DOJ to Department of Health. And it's, from what I understand, around about $160,000, $70,000 is 10% based on the state's last three awards of the grant that we're missing out on. Last year's award, I believe, was $1.77 million. It's in that range from 1.6 to 1.7. It's based on the last 3 years award. Like I said, 10% of that. So anywhere from the 160, 170,000 range. So that's all I have on it, but happy to take any questions of Senator Hill. Thank you.
Great explanation from you both. Any questions, Senator Sparks?
Thank you, Mr. Chairman. Would the AG's office be willing to provide a form that can be used throughout the state so that we don't have inconsistencies from jurisdiction to jurisdiction? Because if we're going to actually qualify for the grant funding, I wouldn't want to miss out on it because one county didn't copy and paste as well as the other one. So instead of copying and pasting, how about let's just have a form that's available to law enforcement?
I can certainly look at that. Like I said, Chairman Sparks, these funds flow through, they don't go to our office, they go through Department of Health. So I would certainly just need to check on, how that works going through health. But
So I'm just offering y'all the burden to provide the form to law enforcement across the state, if you wouldn't mind, or at least arrange that it happens. Thank you. Thank you, Mr. Chairman.
Great question. Anybody else? All right, Senator Hill.
Motion is title sufficient, do pass committee sub.
Heard the motion? Oh yeah, we haven't adopted the committee substitute. So all in favor of adopting
the committee sub.
All right, say aye. Any opposed, nay? Yeah, let's have it now.
Now the motion is for the pass the committee sub.
Motion to adopt the committee substitute. All in favor say aye. Aye. Any opposed, nay? Yeah, let's have it. All right, we're gonna skip around a little bit here. See, Senator Barrett is not with us yet. Well, I'll just go ahead and jump into Senate Bill 2334. There is a committee substitute on this one. And what it tried to do is to combine a number of bills that were all dealing with the same topic, which is, homelessness, loitering, vagrancy, those types of things that we're seeing, at least I'm seeing, and I think if you drive around any part of Mississippi, you're seeing more and more of that, unfortunately, and it's sort of getting a bit out of hand in certain areas, but really in all areas. If you go to the coast, you go obviously in the capital city, down in the Pine Belt where I'm from, Hattiesburg, you're seeing a lot of that. And what law enforcement is telling me, we had a hearing about this. Some of y'all were present for part of that earlier in the very early days of the session. What law enforcement, I think the sheriff of Hinds County was here testifying that here a couple of years ago, we in the legislature basically did a disservice to the law enforcement community by doing away with a lot of the laws that were, punitive, I guess, in nature. Some people thought, so we did away with them. And as a result, we now have very little enforcement capacity because nothing is illegal at this point. So, a citizen calls in and says, hey, there's, someone acting out and, vagrant of some sort here on such and such location. And of course, the police can go out and ask them to kindly move or whatever. But if they say no thanks, there's really nothing that the law enforcement community can currently do to encourage them more forcefully to move or move along or whatever. So a lot of senators, obviously there's a lot of interest in various parts of this. So a lot of senators have filed various bills dealing with squatting, encampments, aggressive panhandling, all these sorts of things. So what you see in the committee substitute is basically all of the bills that came to Judd B at least. Now, there are some other bills and other committees that obviously we have no jurisdiction over, but what I'll try to walk you through is the proposed committee substitute of 2334 that you should have maybe at the end of your packet. I'll hit the summary that I have, and then if we need to dive deeper into any of the sections, I've got all those marked up as well. So I'll just walk with me through it, if you will, and then we'll try to digest it and fix it however we need to. So this creates a new criminal offense to prohibit certain instances of camping, soliciting contributions, aggressive panhandling, and loitering. It also requires a person to have a permit for soliciting contributions and authorizes the prosecuting attorney of a local government to remove encampments under a public nuisance action. So Section 1 specifically provides that it's unlawful for a person to camp upon a street, sidewalk, public right-of-way, any public property, or within 1,000 feet of critical infrastructure unless the location is designated by the local governing authority for the purpose of camping. A violation of this section is a misdemeanor. The first offense would be a small fine not to exceed $100. But then for a second or subsequent offense, it sort of escalates so that the person knows that the law enforcement is serious. The fine not to exceed $250 or county jail for not less than 5 days, no more than 4 months, or by both fine and imprisonment. Section 1 further provides that convictions under this section shall not appear on the person's public record. We're not trying to make it difficult for people to find work. We're just trying to get them to move off of property where they shouldn't be. It also requires a law enforcement officer to provide the person notice of the prohibition against camping 48 hours before any enforcement takes place. So in other words, in order to, if you're a law enforcement person, you find someone camping on public property or places where they're not supposed to be, the law enforcement officer has to go and tell the person you're not to be camping here, you're not allowed to be here. And 48 hours afterwards, they go back. And if the camp is still there 48 hours later and the person hasn't removed himself or herself, then they can start enforcing this with default small $100 fine for the first offense or $250 for the second offense, that type of thing. So notice must be given to the person. Then a 48-hour, waiting period kicks in, and then law enforcement goes back 2 days later to see if they've moved on. And if they haven't, then enforcement can take place. Section 2 provides that a violation of the prohibition on camping is a public nuisance that may be enjoined, abated, and prevented by any prosecuting attorney of the applicable jurisdiction. So the section also authorizes property owners in a municipality or county to request the assistance of law enforcement officers to remove an encampment or to set up any barriers to prevent encampments. Then section 3 prohibits soliciting for contributions upon any street, sidewalk, or public right-of-way without first obtaining a permit from the appropriate local governing authority. The section sets forth a procedure for obtaining said permit and sets limits upon that permit. A violation under the section is a misdemeanor, again, a first offense, fine not exceeding $100, a second or subsequent offense, a fine not to exceed $250, or the county jail for not less than 5 days, no more than 4 months. Section 4 creates the misdemeanor offense of loitering. The first offense is a fine not to exceed $100, second offense, fine not to exceed $250, or again, the county jail for not less than 2 days, no more than 15 days, or both. Section 5 creates the misdemeanor offense of aggressive panhandling, and it defines that. And that's, I thought was interesting how we define that. So you might want to flip over there so you know what the difference is between panhandling and aggressive panhandling. But it's basically touching the person when you're trying to get money from them, basically. Let's see, section 5. I'm trying to get there. I went too far. Thank you. Ooh, I went way too far. I think it's page 7, council tells us. Okay, yes, thank you. So the aggressive panhandling, you're guilty of that if you do one of the following things. You either intentionally touch the person being solicited without the person's consent, by intentionally obstructing the path of the person or of the person, the vehicle the person is in, by following a person who is walking away from you, if you're the one soliciting from the donation, and by making any statement, gesture, or other communication that would cause a reasonable person to feel fear or personal harm for refusing to donate or give monies. And that's what the aggressive, quote unquote, panhandling is. So I just wanted you to know what that was when we're referring to it. Again, the first offense on this one, because it's more aggravated, there is a fine not exceeding $500 or county jail for not more than 30 days. Second or subsequent offense, fine of not more than $250 or county jail for not less than 15 days, nor more than 6 months, or both. And then sections 6 and 7 at the end authorizes municipalities and counties to remove encampments as defined earlier in section 1 of the act on private property. Because oftentimes what you find, the municipalities tell us, and we have representatives here and we can certainly ask them, is a lot of times when you find these encampments or people living in places that don't belong to them, oftentimes you find that the person who is the landowner can oftentimes be an out of town or even out of state property owner, and it doesn't really affect them because they're often wherever. And so you don't have somebody really aggressively seeking to remove the person oftentimes, and yet they're running drugs or doing whatever in these places. So anyway, that is a sort of quick, although not super quick, summary of the committee substitute for 2334. And I'm happy to try to take any questions. Senator Hickman.
So all of the, I guess these would be misdemeanor or criminal actions in here. I think you said earlier that they would not go on the individual's record. Is that for all of them or certain sections?
I know in the first section, section 1, it specifically states that it is not to go on the person's record. Could be. Senator Sparks brings up a good point. That's a city ordinance. So it's specific to the city, not to like a state law or whatever.
Wait. Catch me up here. Rewind. Which part is specific to your?
Well, section 1 deals with it's unlawful for a person to camp on any street, sidewalk, public right-of-way, or any public property within 1,000 feet of critical infrastructure. And the definition of the critical infrastructure means public or private real property or facilities that the local governing authority or board of supervisors designate as being so vital and integral to the operation or functioning of the municipality or county, or in need of protection that its damage, incapacity, disruption, or destruction would have a debilitating impact on the public health, safety, and welfare of the public.
I guess I'm going back to if Senator Sparks, if you were, my question was.
I may have misled the chairman.
Okay.
I was referencing sometimes city ordinance side of the equation is not going on a violation of that, does it go on the record? If it's a criminal act, obviously, that's a different issue, if that was your question, so.
Okay, and I was just trying to figure out, because I mean, I didn't, of course, this is a big bill. I didn't see it, but I think the chairman referenced when he started that a number of these penalties does not go on their record. And is that accurate, or was that a misstatement?
Yeah, and certainly it's not my intention, again, as I stated earlier, to try and keep someone once they get cleared up or straightened out from being able to work. So you don't want to create some sort of public records that someone's going to have problems getting a job or whatnot.
I love that. I was just a little shocked and wanted to make sure that was the actual, what it actually said.
That is my intent. And
Okay.
it's in the summary. Now, if we need to,
I'll
again,
look at
this
it,
is
but I agree.
line 80. Okay.
Perfect.
Thank you. Y'all help me out here.
Thank you.
Line 80. Convictions under this section shall not appear on a person's public record. So yeah, there it is. Does it apply? I guess the question is,
Yeah, is it for the whole bill? Now, that's what I was trying to say, was each one of these sections.
Okay.
It says in each section.
I believe it's just in section 1. If you would like to amend,
I would like to amend it so that it applies to
I have no problem
the
with that.
entire bill or each section.
All right. So Senator Hickman is recognized for an amendment.
I would like to amend the bill so that the language on line 81 applies to each section of the bill that creates a criminal offense.
Y'all have heard the motion, the amendment. Any questions for the author of the amendment? If not, all in favor say aye. Any opposed, nay. Guys have it. Thank you.
Thank you. And then I just have one more question. I just want to make sure, and this was about the municipal part, and I want to, so in municipalities last year, and I think it also came here, I don't know if that was the intent of, I'm guessing it's in section 6. It starts on line 372 and goes to about 490, where basically we add the language in to allow for cleanup of encampments.
Right.
And then, of course, we come back in section 487, because in the beginning it says the municipality shall, and that's in the original statute. So it come back and makes it discretionary. But my question is, does the municipality, under this, your understanding, have to assess a fine to the landowner whose property they clean up for encampments? And I asked that because the bill we had last year said that the municipality could use their funds to clean it up. And I'm just making sure, since it's discretionary, that they're still going to have to charge the owner, and some people aren't getting free service and other people aren't.
Yeah, I think great question. And we've had discussions about this both last session, this session. I think the needle you're trying to thread there is that there's a prohibition of county governments donating public funds to someone. And you certainly don't want to create a situation where the city or county is in violation of the Constitution by giving a donation. I think, again, that's why we make it discretionary. We want to make sure, number one, you either can assess the property owner if, certainly if they're asking for the help, that makes total sense. If the landowner is unable to afford, obviously, to pay for it, if the municipality or county can figure out a way and have funds, maybe privately donated funds or things of that nature that they could use for this purpose. I think there was a bill maybe coming through municipalities that Chairman McMahon, who's done a great job, by the way, both co-chairing the hearing we had on this topic and on trying to get this issue moved forward in this session and last. I think, for instance, in Tupelo, I think maybe they have raised private funds or had people donate funds to the city that would then possibly be allowed to be used for this purpose to clean things up. So I don't want to speak for him, but I know that was a conversation he and I had.
And that's why I asked, because I think that if he has the same legislation last year, then I think that may conflict with this, because here in line 384, I think putting it into this, it says the governing authority shall still by resolution assess these fines, like they have to. And I don't have an issue with that. My only thing is, I was making sure we didn't make the fine discretionary. We make the cleaning discretionary. Like, it's discretionary whether they have to clean the property or not.
Right.
But I didn't want the fine to be discretionary. And that reason, my reasoning for that is because, well, without some, I guess we put in an amendment that put in some safe holes to make sure that municipalities weren't picking and choosing whose property they wanted to clean up
Sure.
and give them this no fee or whatever. So
Gary, do you or Trey have some thoughts? I know y'all do a great job representing our municipalities across the state. If you want to jump in and address any of these concerns about how they go about paying for or getting reimbursed for the cleanups. Sure. So would you say that argues in favor of the shall, so that you just say they have to do it? Or you want to give them some leeway? Right, sure, sure, sure. So discretion as to whether you clean it up or not, but then the payment on the ones you do choose to clean up, I think the second part of the question is how to pay for that. Do the cities have the funds themselves to? Right, against the property. Okay, that's the only mechanism that they really have at their disposal. Okay. Did that answer your question, Senator Hickman?
that answers my question. But my only thing that and the bill does exactly that. It gives
Okay.
them discretion whether to clean up, and then it does not give discretion at whether they shall assess the fine.
Okay.
I wanted to make sure that was the case. I didn't know if I remember you said you incorporate all the bills. I didn't know if you were incorporating the bill we had last year and your intent was different because the bill we had last year intent was to allow them discretion as to whether they would assess the fine or not.
No, no,
Okay, perfect.
you're right. All right, Senator Hill.
So my question is about leaning the property. So you're talking about leaning the property if the property owner won't run the homeless person off and clean it up? Because like if they're out of town or something, they got a piece of property and there's a homeless encampment on it. The city, I'm sure, or I hope would give them some notice about cleaning it up because, I mean, yeah, well, I'm talking about that they said that they would lien the property. I mean, just like they do for blighted property. So you're gonna lien the property to clean up the homeless mess, just like you'd lien it for blighted property. But what I'm saying is, it may not be the owner that's on that property that's blighted, that somebody's camping on. I
Right.
mean, they might just have property and there's people made a homeless encampment on it. So what I'm saying is to make sure the property owner was noticed about this cleanup before they
Yes.
go to clean something up and lien their property.
Yeah, absolutely. At the landowner, I think that's the way it works now.
It is the way it
You
works
reach,
now.
you reach out to the landowner and say, hey, we've got some problems. And oftentimes, most times, it's probably the landowner themselves that come to law enforcement and say, hey, these people are on my property. I've asked them to move. They want, I need help. But in the case of the absentee landowner that you're talking about, which happens sometimes, they do get contacted first to give them the option first to use their own persuasive abilities to get the person to move. It's, I think, going to the next level if, number one, they can't be found or they are found and they're not cooperative and because they're in, Colorado or whatever, and all these things are happening on their property on, the middle of Main Street,
Gotcha.
you got to be able to do
Yes.
the next step or
I
whatever.
just wanted to make sure that it was gonna be the same process of making
Yes.
blighted property.
Great point. That's my intent. And if y'all see that's not the case, we need to fix it. All right, Senator Norwood.
Chairman, I'm trying to understand the fines. So there'll be a progressive fine, this. I mean, most of the guys that's going to be, that you would be picking up off the street, they can't pay that. So they're gonna be in the jail. And when their time is up, they're gonna be right back on the street, or the county's gonna be responsible for assuming that. So, I mean, it would help my thinking is that if this is gonna be the case, is that the county would, I mean, there's gotta be some type of plan, a plan in place to make sure that once they are picked up,
Right.
that they're not just held there, or they're not released back out, because they're released back out, they go into um, another place, I guess. Is that,
I think you raised an excellent point, and I think the hope is, at least, is we may, best laid plans of man and mice often go awry, but I think the idea behind this is, as we heard in our hearing a couple of weeks ago that you were present at, um, about 85% of people who are quote unquote homeless either have a substance abuse problem or a mental health problem or a combination thereof. So the hope, at least, and the idea is that number one, you're giving all these people notice, like 48 hours notice to please, you know, pack up and move. And if they have the wherewithal to do that and they leave, then nothing ever happens. But if they're still there 48 hours later, when the law enforcement goes back and it progresses to the point of a second offense, they only get a fine the first offense anyway, but the second and subsequent offenses, if they do actually end up being taken to the jailhouse, the hope is that they're going to get evaluated for, mental health and for a substance abuse and get some help through that process. Now, we can't mandate every little bit and piece of this, but I think this is a serious first attempt at trying to get people who are having mental health breakdowns and or substance abuse breakdowns into a public facility of some sort where they can get evaluated and maybe get some assistance that the state or the county could offer to them.
right, and I'm approaching from not from a legal standpoint, but
I'm sorry.
approaching it not from a legal standpoint, but from a social worker standpoint.
Right,
It's not gonna be just gonna be revolving door to bring them in and to go right back out.
right.
And if we can make some type of, I mean, there should be some type of provisions or resources made available for the counties or those institutions within that county to be able to coordinate or collaborate with the local department to make sure that it happens.
I would love your idea if you want to make a conceptual amendment to that effect, that any persons that are picked up and transferred to the county or city jail in these instances would be, evaluated for mental health and or substance abuse issues. And then resources could flow in that respect. If you would, I don't want to put words in your mouth, but that sounds like what you're articulating. Okay. So you've heard the conceptual amendment that Senator Norwood articulated. Senator Sparks.
I guess the question on the concept is if some language was inserted, maybe that the Mississippi Department of Mental Health give us some guidelines or give us some advice on that, since, and, our community mental health centers may be able to help, but maybe, and maybe they'll help us with some language on that conceptual.
I would love that. Yeah,
you.
absolutely. Did we vote on the amendment about the Hickman's amendment? Senator Hickman's, okay. Someone had said we didn't, so I thought we had, but I just want to make sure. Okay. Senator Thomas. Yes, sir.
On the law enforcement issuing, it's a written or oral notice. They must vacate within, what is that, 48 hours?
Yes, sir.
Okay. If we could track that, we need to have some way that once it's, I don't like the oral,
Okay.
it needs to be written, but once they give this notice, that notice can then be given to an agency or somebody, and that would trigger the time. Like several things could happen. Officers could get the time mixed up and come back in 6 hours. But my thing is to help get to some case management, social service group,
Sure.
and maybe they could drive by or stop and talk and see what's the problem or some of the problem.
I hear you. I don't disagree. I think the concern there is, unlike a permanent structure where you can post the notice if the person isn't there at that moment. If you're talking about a tent or a lean-to or some sort of, quickly assembled little lodging, there's not really the ability to post, I guess, in a way that would still be there potentially.
If they're there, just hand it to them with a date
Well, sure, that would be preferable, but what if they're out panhandling and they're not at their little camp, but then later on they are back at the camp? I mean, I think that was the reason why we had the or, but it's a great question. All right, any other questions? We had already voted on the amendment, so we did not. So Senator Norwood articulated an amendment, and you've heard it. All in favor, say aye. Any opposed, nay. The ayes have it, and we need to refine some of that language if y'all will work with me on that. All right. Any other questions, concerns? If not, the motion is title sufficient to pass committee substitute. All in favor, say aye. Any opposed, nay. The ayes have it. All right. Thank you for that. It's a work in progress for sure. So bear with us on that. Senator Blackman is here on Senate Bill number 2319. We will recognize him if he will explain his bill to the committee.
Thank you, Mr. Chairman. 2319 is pretty straightforward. It creates a series of escalating fines for discharge of a genetic material without the intent of fertilization. It has in it exceptions, and those exceptions are if it's donated or sold to a facility for the purpose of future procedures to fertilize and discharge with the use of a contraceptive or contraceptive method to prevent fertilization. It's my understanding that there will be an amendment offered to change wherever it says the word embryo to say egg. And additionally, I'd also add that this quote says there's no substantive due process right to stimulate one's genitals for non-medical purposes unrelated to procreation or outside of an interpersonal relationship. Those are the words of former Solicitor General Ted Cruz, now Senator Ted Cruz in Lawrence v. Texas, whose stance was backed by the dissent of Justice Antonin Scalia. And this quote, I want more babies in the United States of America. I want more happy children in our country, and I want beautiful young men and women who are eager to welcome them into the world and eager to raise them. Those are the words of Vice President J.D. Vance in his first speech as Vice President at the National March for Life. So I believe this is a very conservative bill. And I guess I'll find if I'm one of the most conservative senators around. And I'll be happy to entertain any questions that may arise.
So what is the objective? Like, what are we trying to accomplish with the legislation?
What we're trying to accomplish is unwanted pregnancies and the need for abortion procedures if there's an unwanted pregnancy.
You're trying to remedy unwanted pregnancies, or you're trying to create more?
I said trying to prevent unwanted pregnancies.
Okay. Senator Hickman.
That is to change the term embryo to egg.
Embryo to egg. All right. You've heard the amendment. Any questions?
Question on the amendment.
Or recognize?
Why do you want to change that language? What's the intent of changing the language of fertilizing an embryo?
Mr. Vice Chair, I'm gonna ask that you would address that question to the author of the bill. Since he's not on this committee, I'm making that.
Oh, no, I mean, it's an amendment. I'm just asking why the
for him.
amendment of not wanting to fertilize an embryo?
You don't fertilize an embryo, you fertilize an egg.
I realize that, but I'm asking why is it an embryo in the bill? Got to be real careful because an embryo, an egg, I don't think anyone would say within itself is life. It's a vehicle to life. Joined by another genetic material, if God sees fit to bless you, that comes together in a union, it creates an embryo of which many of us seek. So that is correct. You cannot fertilize an embryo because it's already life to so many of us. So I don't object to the amendment on the grounds of factual accuracy. I was just curious why we use the word embryo to begin with.
It was an oversight. We often have oversights in all of our legislation that we have to correct, and that's what I'm doing here now.
And that's fair, but I just want to make sure your position is that an embryo is the post-joining of two genetic materials that is the beginning of the creation of life, separate and apart from the two donors of the material.
Yes, that's why we're changing the language from embryo to egg.
I just want to be clear. Thank you. I support the amendment.
Precisely all of that.
All right, any other questions on the amendment? Senator Hickman. All in favor say aye. Any opposed, nay. The ayes have it. All right, Senator England.
Question, Mr. Chairman. Thank you, Mr. Chairman. Uh, Senator Blackman, I probably have a few questions, but I'm just going to keep it, I'm going to try to just ask one. And honestly, with all the press that this bill has gotten, I kind of expected it to be a little bit longer, but it's actually pretty short.
It is.
Um,
It gets to the
I
point.
w- But I want to add, the question that I want to ask, I don't see genetic material defined. And so the discharge of genetic material, I'm often walking through the woods hunting and I might scratch my arm on a branch and bleed, which has my DNA in it. Have I violated this law if I do that? Because there's no embryos or eggs around when I'm in the woods that I know of. And I have cause from my body to spill genetic material with my DNA in it. Am I gonna be fined for that?
Well, I am no scientist. I am not a healthcare expert.
Well, this
so-
bill has a lot of scientific terms in healthcare. Did you
I
talk to any
understand-
scientists?
I
or healthcare
I understand that, and the vast majority of bills that direct with what a woman can and cannot do with her body are not done by people with that same expertise. So I would say that I can get you that answer.
Do you have any idea what the answer might be? What your definition of genetic material might be?
At this moment, I'm not going to be wrong, so I am going to get a more thorough definition to give you an answer if it comes out of this committee, and if it's on the floor, I will have an answer for you.
Okay, I would like an answer to that one.
I'll
if-
get you one.
If the bill passes. Thank you. I don't really have another question, but I will say that if the intent of this bill is to make sure that men are being held more accountable to be fathers to children, which we all do want to happen as conservatives, correct, Senator Blackman?
That's correct.
We want to see children born into this world, correct?
That's correct.
And so I do want to say that I agree with if the intent is to make sure that fathers are making sure that they're sticking around and maintaining their relationship with their children and caring for their children, I would agree with that. I don't think this bill accomplishes that, and I'd like to work with you, as well as probably many of our other fellow conservatives would like to work with you on that. And we'll welcome you into that conversation going forward. I'm just not sure that I'm satisfied with what this bill does.
And that is the intent. That's why the exemptions are there for use of contraceptives. If you're using contraceptives, then you're not intending to fertilize an egg, and you're not intending to create an embryo that will then hopefully become a living, breathing human.
Thank you, Senator Blackman.
All right, other questions? Senator Hill.
I have two.
Sure, you're recognized.
The first one, a woman, when they reach puberty, they begin releasing an egg every month, if everything's going right. So basically, is that woman going to be now a criminal if she doesn't have sex when that egg is released on a monthly basis? Because that's genetic material.
I don't see where it makes them a criminal in the bill.
It shall be unlawful for a person to discharge genetic material without the intent to fertilize an embryo,
We'll fertilize an egg.
fertilize an egg.
I'm not aware that a woman can fertilize her own egg.
Well, if her intent's not to fertilize the egg, that makes her guilty. She can't help releasing the egg.
It says release genetic material without the intent to fertilize an egg. I am not aware that she can fertilize her own egg. If you're aware of that and there's something that can be pointed to that says that, and if there is an amendment that you would like to add, I will be in favor of that. I'm not on the committee, so I can't be.
This basically says that it's unlawful for a person to discharge genetic material without the intent to fertilize an egg. She can't fertilize her own egg, but she's discharging genetic material. And how do we know if it's her intent to have that egg fertilized? You can't know that. So if she doesn't have sex and doesn't have intent to fertilize that egg, the way I read it, it makes her a criminal. And the second question is, have you ever heard of menopause? When a woman reaches the age that she no longer can have children and she no longer can release an egg that could be fertilized? Are you advocating in this bill that women should be abstinent after they reach menopause? Should they not have any type of intimate relations with their husband because it's not possible to fertilize an egg with a woman that's past menopause? So I think we're making her criminal too in this bill, and her husband, if they have relations.
That's not my reading of the bill, but if that's your interpretation, I have nothing that I can say on that one.
I motion to table the bill.
Sorry, I jumped the gun there. I'm sorry. Oh, no, I had a question. I apologize. For Senator Hill, do you think it might be better in this bill that if we said it shall be unlawful for a male, a man, would that help a little bit? Since there's two genders and one, as you've defined, has the egg responsibility. So we don't say person. Would that clear up some of the confusion?
I think regardless if it's the male or the female, if they,
But I'm just saying that would clear it up because you said egg can't fertilize an egg, but we won't do that if you don't want to.
no,
My question, and I think you asked this, and I guess for the author, a conviction, is this a misdemeanor or is it a felony?
I would believe that it'd be a misdemeanor. We can add language that clarifies that it's a misdemeanor. And if you can see, it's more on the honor system. If you want to turn yourself in, then you can turn yourself in.
Well, I mean, it's a conviction. You're not talking about spiritual conviction, are you? That comes before repentance. Godly sorrow worketh repentance, which leads to salvation. Is that the kind of conviction we're talking about? Or are you talking about a criminal conviction? It doesn't say criminal conviction, but that could be correct. That could be 1,000, 5,000, 10,000 to drop into the treasury at the church. I'm just curious.
Well, if we,
Well, because we're really talking about sexual immorality, because we're talking about sex outside of marriage. Is that not what you were saying when you were quoting J.D. Vance earlier, that they're eager to welcome and to take on the responsibility? They're having an act here that creates life, and you're wanting them to be eager to welcome them. But I'm just curious to start with, is this moral conviction and donation, or is this criminal conviction? And if so, is it a misdemeanor or felony?
well, people do not have to be married to have children, and I'm not saying that you have to be married. That's not any intention of mine to say that people have to be married to have children. There are plenty of people who bring children into this world who are not married. And if we want to get into the Bible, we can point out that spilling God's seed on the ground was seen as a sin. So
that's the first thing I thought of when I read your bill. That was the first thing I thought when I read your bill. I thought, man, he is moving so hard to the right that he'll make J.D. Vance blush.
Right? See?
Yeah.
I could have called it the Musk Act or the Vance Act.
Yeah.
But I would say that it'd be a misdemeanor if you were found guilty of this, and with that criminal fine. It does not impose any jail time on anyone.
But it's a crime. I'm just,
yes,
because that leads to my final question. Is this an intent crime?
yes.
Okay.
All right.
Without the intent. Are you telling me some of these children that are born out of wedlock were all with intent? I would say most of them are without the intent of pregnancy, so they wouldn't be guilty, would they?
No, they would be
Pregnancy
guilty.
results, but they didn't have the intent.
No, they would be guilty of this because they did not use contraception, and their intent was not to fertilize an egg.
Okay. All right. Thank you.
All right. Senator Hill, you recognized for a motion.
motion to table.
Heard the motion. All in favor say aye.
Aye.
Any opposed, nay. The ayes have it. Thank you, Senator Blackman. All right. Senator Barrett has joined us. We are going to go to 2803, and we'll recognize him to explain the bill.
Thank you, Mr. Chairman. This is.
Is that working? I did. It is. It is.
Thank you, Mr. Chairman. This is a bill that we passed. Yeah, I don't.
All right, y'all listen up.
Yeah, thank you, Mr. Chairman. This is a bill that we passed out of here last year. It deals with, all-terrain vehicles and utility-type vehicles. This would require titling of those, vehicles. As most of you know, a lot of these ATVs and UTVs can reach up to $55,000, $60,000. I think when the title law was initially passed, automobiles, including cars, trucks, farm equipment, boats, things that are cheaper than ATVs and UTVs require titling. I think it's time that they do hold a title. Although Mississippi is not a title state, obviously there is no greater proof of ownership than having a title. And that's the first part of the bill, Mr. Chairman. The last part is similar to car dealerships and other dealerships that handle an inventory. This would make ATV and UTV dealerships exempt from ad valorem taxes on their floor plan. So if they had 20 vehicles financed on their floor plan, those vehicles do not belong to them. So the ad valorem tax associated with that floor plan, they would be exempt from that. And Mr. Chairman, lastly, I understand that a lot of ATV and UTV dealerships, the counties are not charging ad valorem taxes on that, but some counties are. So this would clarify that. Yes.
All right, sorry about that. Senator Hill, Senate Bill number 2197.
Thank you, Mr. Chairman. What this bill would do is make Mississippi's law of impersonating a police officer in line with the states that surround us, including Tennessee, Alabama, Arkansas, Texas, Florida, and Georgia. And after those, I just stopped looking because every state that I looked, that was 1 to 2 states over for us, impersonating a law enforcement officer was a felony in those states. So that's all this law does is change from misdemeanor to a felony for impersonating a law enforcement officer, and changes the fine. Right now, the fine can only be $100 maximum. So it puts us in line. I did half of what Texas's fine is. Texas is up to $10,000 and up to 5 years, and we did 3 years and up to $5,000.
Okay, you've
And
heard the explanation?
That's an explanation.
All right, any questions? Senator Sparks?
Is this just specific to Mississippi Highway Patrol?
No.
I just want to make sure it's not
No, it's not.
limited.
No, it's not limited.
Okay,
Okay,
thank you.
any other questions? All right, for a motion, Senator Hill?
My motion is title sufficient, do pass.
Heard the motion, all in favor say aye.
Aye.
Any opposed, nay? The ayes have it. All right, Senate Bill number 2204. This one deals with requiring centralized registry for all reports of stolen farm-related vehicles. Apparently, this is quite a problem, especially more in our more rural areas. I think even our own Lieutenant Governor's had several of his ATVs stolen here of late, up in Holmes County perhaps. But it's not unique to him. I think this happens a lot. And so we already have this bureau set up over at Mississippi Department of Agriculture and Livestock, the Theft Bureau, that was created, I think, some time back. But unfortunately, our law enforcement don't always, I guess, know to report these stolen farm-related vehicles to said entity. And so what this bill simply does is require the sheriffs, chiefs of police, director of highway patrol, or constable, or any other peace officer in the state to report to the Mississippi Agricultural and Livestock Theft Bureau all reports of stolen farm-related vehicles. And then they will keep a registry, and that way we'll better know how big of a problem this really is and maybe how to take action to prevent it. But it's hard to know what to do if you don't know the scope of the problem, I suppose. So it's just trying to get some registry of these reports going on for the farm-related vehicles. That's what it does. Any questions? Not, the motion is title sufficient, do pass. All in favor say aye.
Aye.
Any opposed, nay. The ayes have it. And then I think we are down to Senate Bill 2313. Senator Hill. Are you ready?
Sometime back in this committee, we gave immunity to anyone who was reporting an overdose. If there were actual drugs or alcohol involved, we gave anybody that was, with those people, even if alcohol or drugs, if they were reporting an overdose, we gave them immunity for the drugs and the alcohol that would be on the scene. What this does is gives the same immunity for reporting a sexual assault that we gave for reporting an overdose. It's the exact same language. This was asked for by those that work in the sexual assault arena, the advocates, for those people. And they feel like that being that sexual assault's like one of the most underreported things, especially on college campuses. If there's an awareness out there that some freshman kid in college that gets sexually assaulted knows that they won't be arrested, maybe they're underage drinking or there's drugs or something at a party, that they would be more likely to report the sexual assault. And that's basically all it does. And it says you can't have your parole or probation revoked or something if you're there and you're reporting a sexual assault or you're the victim.
Okay, my only question, I'm totally with you on what we're trying to do. I guess my only question that I've heard from anybody about this bill is what is to prevent every person that's about to be arrested, every woman for drunken driving or some sort of drug offense to say, oh, I was raped or I was sexually molested. Is there any concern whatsoever that this will just be used as a defense and every time that one of those situations arises?
That was not brought up to my attention, but I think the fact that a reporting, typically there wouldn't be law enforcement officer on the scene until there was reporting. So that was the scenario that was brought to me on this bill.
Okay. Fair enough. Senator DeBar?
Thank you, Mr. Chairman. That was kind of my questioning. Is there a remedy for a false reporting of a sexual assault? I mean, that happens very rare. I gotta understand that. But if there was a situation like you indicated, Mr. Chairman, is there a remedy for something, or should there be a remedy? And I'm just raising the question moving forward.
Well, I think, that would stand true for anything, just like y'all were talking yesterday about people reporting domestic violence. We can't look at a potential remedy to keep somebody from reporting a sexual assault. That's my thinking. And if it becomes a problem and we see that happening, more than happy to go back and readdress it. But I don't know what you can do other than saying, that the person's lying if they're reporting a sexual assault. But typically, they're not going to report the sexual assault right then and there. They're going to report it when they realize something's going on, unless it's something that is so egregious that, there's people around and they're reporting it. And that could happen too. And actually, we have had former senators in this chamber that we know whose daughters have been sexually assaulted on college in the areas colleges. So that's the concern about the bill. And I mean, you got the same thing with somebody overdosing.
True. All right, Senator Hickman.
I just had a quick question. I was looking through here. What are we giving them? What are the things? Is there an exhaustive list of what we're giving them immunity from?
Immunity from prosecution for drugs or alcohol, or for revocation of probation or parole if they're reporting a sexual assault.
Okay. And I guess I guess looking at this, I'm guessing what would happen, which is kind of a remedy, if they find out that it's a blatant false report. I mean, not from the person, it could be from somebody who was there in the room. If it's a blatant false report, I'm guessing they just charge them with the underlying crime they would have charged them with anyway, whether it's drugs or alcohol or whatever.
I mean, yeah, there's no reason why if they find that it's not valid, I don't think there's anything that says you couldn't charge them.
Senator Sparks?
Thank you, Mr. Chairman. As I read line 21, it's that the actual peace officer has contact with the person because the person requested So,
Right,
that goes back to what you said.
that's
they
why I said they
start
have to
the
call
engagement.
them. They
I get
have to.
pulled over on the
yeah.
side of the road. I see blue lights behind me.
No.
It may be that I was driving away from an event that I might be reporting.
They have to request it.
Okay.
That's a better way to clear it up than how I explained it. So thank you for stepping in, because it's basically they have to request the assistance.
Thank you.
Okay, good question. Senator Wiggins?
Thank you, Mr. Chairman. I'm looking at lines 113. I guess I'm having a hard time. Are you saying that there are instances where a sexual assault victim makes a report and is under, I don't know, is either taking drugs or alcohol, and they've been arrested at the time they reported the sexual assault by the law?
I cannot give you a specific example, but I can't tell you that it doesn't happen or it hasn't happened.
Well, I guess that's where I'm going, and I
And I mean,
understand what we're trying to do. I just have never heard that law enforcement, when they take a report of sexual assault, that they then turn around and arrest that person.
well, it could be the person reporting the sexual assault and not the victim.
Oh, you're saying, you're
Yeah.
like it's
Yeah.
a different person.
Yeah, it could be the victim or it could be another person.
Okay, so
They would have to instigate the contact with law enforcement.
I know it's hard to deal in what is, but if a person under the influence walks up to the police officer and says, "Hey, my girlfriend was sexually assaulted," the police officer can't then arrest that person who just went up to him. Is that what we're getting at?
If he's calling them to come investigate a sexual assault or contacting them to come investigate a sexual assault, it would, you can't just use that and say that to keep from getting arrested. You would have to be contacting law enforcement to say, we've had a sexual assault, please come investigate, come help.
And okay, I'm understanding. So the whole point under the bill that we originally did was to encourage people to report an overdose.
Yes, and
You're
we're,
saying
yes.
this is to encourage
Exact,
people to okay,
exactly,
I understand.
exactly.
Sorry,
The same exact parallel to encouraging people to not let somebody lay there and choke to death and suffocate is to not let somebody be a victim of sexual assault without seeking justice. That's the same principle.
I think that's a good explanation, yeah. Very good. All right, anybody else? Question? All right, for a motion, Senator Hill.
Motion, title sufficient, do pass.
All in favor, say aye.
Aye.
Any opposed, nay? The ayes have it. All right, and final bill today will be the one on the tail end of the agenda here, and we'll recognize Senator Sparks to do the committee substitute explanation.
Thank you, Mr. Chairman. This addresses bail bonds. We've looked at these bills, very similar language a couple different times. Just a quick refresher, if someone is arrested, they would oftentimes bond out with a bail bonding agent. That bonding agent has duties and responsibilities to make sure that that person returns to court. That period of time that's generally covered is a 36-month period. That's a contractual relationship between the surety, the bonding agent, and the person who's bonded out, but it's to try to assure them coming to court. In some circumstances, people fail to go to court, and at that point, there is a judgment nisi. There's basically a warrant issued, and at that point, the bail agent has a duty to try to locate their client and deliver them to the court. If they do, in fact, deliver them to the court, they request what's called a set-aside order. So otherwise, the bonding agent would have to pay the bond amount to the court. So the first adjustment is that we're making a point that if someone is met the criteria of returning the person to the court or bringing them back into compliance, that the bonding agent who works under the Department of Insurance as far as their governing body to protect their license has to make sure that certain things are done. And so the first part you see in 35 is that when we're trying to get a set-aside order, the clerk can accept an order on behalf of the surety to submit to the judge. Now, whether the judge wants to sign that order to set aside or their own order, The bonding agent just wants to make sure that they don't get their license revoked. Also, that the felony warrants for non-appearance is put on the NCIC system, because again, the duty is to bring these people to court. And if there is a warrant issued for non-appearance, that would be placed on the typical NCIC system with no restriction in the attempt to return the defendant to custody. When we get to line 67, that was 10 working days. So this is a situation where a final judgment is entered against the surety, meaning they have not been able to locate the person, which at that point, the Department of Insurance moves very quickly, not to just say, give me the money, but to revoke their license if they don't deliver this person. So we're changing that number from 10 working days to 30 to make certain that they can get notification to this licensee. Otherwise, their license is revoked. Now, the surety can give proof, as you see in 72 through 74, to the proper authorities that there's a receipt that they actually paid the bond off, a surrender certificate, or notice of surrender. That is what the bill does in Section 1. It repeats that again in Section 2, going from 10 to 30 days. Also, the proof before revocation that they've met the terms and conditions of the bond, and that the clerk shall accept an order on behalf of the surety to submit to the court. And the final piece in Section 4 is the bail bond obligation that generally runs for 3 years or 36 months, ends in that time frame, or when the defendant's found guilty and sentenced. So once they're sentenced, there's no need to be on bond anymore. They've completed that. The charge is dismissed or null price. The charge is retired, remanded to the files. And you see all of that in 330 through 340, that the defendant is sentenced to a non-adjudication program or some other type of sentencing. So it requires a sentence, in other words, a finality of your case. That is an explanation of the bill. Mr. Chairman, I would yield any questions.
Excellent. Senator Simmons?
Thank you, Mr. Chairman. Senator Sparks, was this the bill that we actually passed our committee last year?
It's very similar, yes.
I just know one objection that we heard on our side and also on the House side dealt with what happens when a sheriff had to actually leave and go and pick up someone out of the county. Is any of that language in here?
There is no mandatory language making the sheriff go do anything. Now, the question is, assuming I have someone that's arrested in Tishomingo County and we find that person in Alcorn County, pretty easy, the sheriff's going to go get him. If he's in California, the sheriff may not want to go get him, but the bonding agent will want to go get them depending on the bond. So I think based on my conversations, the bonding agents and the sheriff's departments are working pretty well together to try to do that. And I think there will be potentially future legislation allowing that opportunity, because more time that law enforcement can spend enforcing the law and not going after to get people, and bail agents get to go do that, that would probably be better.
Thank you. Thank you, Mr. President. Thank you, Mr. Chairman.
Question and explanation. Anybody else? All right, for motion, Senator Sparks.
Title sufficient, do pass committee sub, or do we need to adopt it or just pass it committee sub?
Pass it.
Committee sub then.
All in favor say aye.
Aye.
Any opposed? No. That's the last one for today. We are going to meet again on Tuesday, so stay tuned for a committee meeting there. Senator Hill?
I'd like to hold Senate Bill 2191 from yesterday on a motion to reconsider.
Heard the motion? All right, rise and report. Thanks.